this computer. Alrighty. We are at week 5. Woohoo! Hasn't that spun by quickly? I was in the middle of just saying if anyone has had some difficulties with their studies because of TC Debbie, just drop me a line, explain to me your problems, and we'll see what we can do for you. I'm not anticipating that there should be too much fallout for this particular unit because, we've got the first assessment really isn't for a few weeks yet. And you've had quite some time to start, researching that collaboratively with your colleagues. So I'm not anticipating. Hi, Joselito. I am not anticipating that there should be too much fallout in the way of nasty Cyclone Debbie. But like I said, if you are having some problems or there are other problems and difficulties, I understand there has been some issues with getting a hold of the text. Drop me a line and let's work that out sooner rather than later. Okay, I hope you are all well. We're almost halfway through the unit. Hasn't that flown? Wow. Don't know where time's gone by, but anyway, any of you guys on Twitter? Okay, I posted up some photos, which I actually might post up on the Moodle site for those people that are not on Twitter, but I saw some rather glorious knockoffs on the weekend. I happened to spend a few days in at Surfers Paradise, home of all things knockoff in Queensland, and I saw some great basketball caps which had the Michael Jordan, the Air Jordan logo, except it was Batman. that was making the basketball jump, and I thought it was rather hysterically funny, so I posted it up to Twitter and got a few likes there. I'll post up the pictures for you. If you want one of those hats, you're going to have to make your way to Surfers Paradise, I'm afraid. But they also had Minion knockoffs and Superman knockoffs and pretty much any other kind of knockoff you could think of, all available in basketball caps there for $10 a throw. So I don't know if you guys get to see many knockoffs, but these were really rather funny. Anyway, on a more serious note, we should get kicking off with today's workshop. We are looking at this week passing off and the Australian Consumer Law and the Competition and Consumer Act. And without further ado, I will share my screen so that we can get to our document. Okay, so we have got, whoa, there we go. Here's our normal scenario that we've been looking at. And this week we are looking at it with our passing off spectacles on. We are also looking for vestiges of any Section 18 action that we might be able to bring for misleading or deceptive conduct, or potentially some issues, particularly with McDonald's and Hungry Jack's. I wanted us to look at the issue of Section 46, misuse of market power. Okay, so just flipping down to the questions for this week. Before we actually jump on in, does anybody have any queries in relation to the action for passing off? No? All fairly self-explanatory. Have you come up against this action anywhere else in your degree studies so far? Not yet? Okay.
In torts.
Torts?
Yeah, torts.
Yeah. So this week actually shouldn't pose too many difficulties conceptually. I thought you should have come up against the action for passing off somewhere. Also, misleading and deceptive conduct, I'm assuming, would be contract B. Is that right? Yeah, contract B. And you said that you'd done the restrictive trade practices also. So, you know, this is largely review material for you, I guess, so it should be a bit of a cruise. But we'll just, you know, do a bit of a hunt and peck through the questions and see if we can rummage through our past experience to come up with some answers here. In relation to Fred's conduct, now, remembering Fred was the guy that was a part-time manager and had access to Nigel and Roy's recipe, got all the good secret stuff, had used the burger flipper tool, knew how to use all of that. He then sets up business across the street. Across the street. There's one thing I want you to know. And what did he call his business? Hungry, Eat It, Max. And if you think I'm original in this, I'm actually not. There was a wonderful little burger joint down at Tugun, which is somewhere near Coolangatta, if you know the Gold Coast, about probably half an hour south of Surfers Paradise. And there was a large Hungry Jack's establishment on one side of the highway, and on the other side of the highway was this lovely little mum and dad burger joint, and they called it Hungry in big fat capital letters with a tiny little eat at and then Jack's. So for all intents and purposes, when you look to the left of the highway as you were heading south, you'd see Hungry, something unintelligible, Jack's, and you'd think, oh, Hungry Jack's, and then you'd turn to the right of the highway and there was a Hungry Jack's establishment there. Obviously, you knew that the mum and dad joint was not the real deal, but certainly they had tried to cash in on their position relatively close to an authorised Hungry Jack's. So they're the facts that we've got. Let's have a little look at the action for passing off. Now, do you think that Nigel and Roy could establish a sufficient reputation? Let's quickly flip back to the facts here. They opened their first store in the centre of Smallville. Soon as they opened, crowds flooded in and business boomed. Okay, we don't know how much time has gone by, okay, but we do certainly know that they seem to be enjoying a fair degree of commercial success in their early operation period, okay. All right, what will we be saying about reputation? Anyone hazard a guess? You're acting for... Sorry, go.
I was just going to say that it seemed by all accounts that they did actually have one, but I mean, you know, different perceptions of reputation, I guess. Yes.
So you're going to be saying things like they're in the centre of town. So that would probably give them a fairly high degree. Do you think I'm overstating the case? A fairly high degree of exposure. I'm guessing, being the middle of town, that they would enjoy a fairly high trade of passers-by. Yes, you know, foot traffic, or what they call walk-ins.
Well, I would say that depends.
Yep.
Because they could have been down an alleyway off the main street.
They may be.
Well,
Bianca is a good devil's advocate.
No, the reason I say that is because when we were in Thailand, we were walking down the main street of the town we were in, and we just happened to look down an alleyway, and we found the most amazing Indian restaurant.
And aren't they always in alleyways?
Well, most people would have just walked right past it. But, you know, we just happened to look down there and went, oh, there's an Indian restaurant. We'll go for lunch there. And it's probably the best Indian we've ever eaten.
Yes, yeah.
But, yeah, I mean, and it was in the CBD, but it was down an alleyway. So that doesn't necessarily mean you're going to...
So we would need more facts.
More arguments.
About where they were located and what the exposure was exactly, to be sure. Yep. Sure. I found the same thing in Tokyo. All the best restaurants were hidden away, kind of hole-in-the-wall establishments that kind of you only found out, you know, by if you knew locals or you knew people that had been there before. Okay, so if they are located on a main street, here, if located on a main street, they'd have a fairly high degree of exposure. Yeah. We do know that business is booming. So I guess even kind of almost regardless of whether they were in an alleyway, you could say, I mean, if you were their lawyer, I guess you're looking for the highest possible way to present their facts. I guess you could say, given that business, was booming, it appears there was at least some degree of public recognition, yes? Probably, given that they seem to be having a fairly brisk trade. Assuming that we can get over this, and obviously Bianca and I have been kind of going tit for tat on whether or not we could establish this, and this is typically where you will fall down if you are a relatively new trader. This is the big problem. There was did you in torts cover the Targets case? The Target Australia and Targets, Targetts. There was a little tiny trader, I think it was somewhere, out in the sticks, like, almost not in Australia, like Tasmania. And, oh, sorry if anyone comes from Tasmania. There was a little tiny trader and they were targets. And everybody in the town knew them as Target, and that's how they traded. And they traded that way for many, many years. And then the big bad US company decided to move into Australia, and they wanted to stop them. Now, the problem there geographically was that they could only show their reputation was in that town. So you can't then try and prevent Australia-wide trading by the US conglomerate moving in if your reputation is only quite geographically limited. Yes? So this is where you will tend to mostly fall down in this kind of action. Assuming we can establish reputation, then do you think that there was a misrepresentation? Let's go back to the facts. I don't know why I've got a I've got a whole blank page there. I'm not, whoa, okay. Misrepresentation. What's he done? Fred has set up business across the street and he's called it Hungry Eat at Max. So on the one side of the street we have Hungry Max, and if you turn your head on the other side of the street we have Hungry Eat at Max. Do you think that that is sufficient to constitute a misrepresentation that would lead people into?
I would think so, yeah.
Yeah.
Definitely. It's on the, if you go to, for example, Google, and you type in the first word, hungry restaurant, and the street name, you're going to get two options of the same.
Yes, exactly. I think you probably could. Hungry Max is, I would say, deceptively similar to Hungry, and this is how my little mum and dad joint did it. Eat at Max, and they did it like this. With a and a and you can imagine the same thing going on here, can't you? I think so. And we'll talk a little bit more about being, deceptively similar when we come to misleading deceptive conduct. Damage. Do we see any damage in the actual facts? Let's have a look here. He applied all the knowledge he gained at Hungry Max. He replicated the burger flipper easily. His business immediately impacted on their profits as his burgers were cheaper. Okay, so I think we can say safely, yes, he diverted profits. His burgers were cheaper and customers went to him thinking they were getting a Nigel and Roy burger, but for less money. Yeah, that's how you'd be making the arguments for passing off. Okay. Misleading or deceptive conduct. Again, this should be very familiar to you all. Is Roy a person? Yes. Big tick. We don't have any of the previous problems that we used to have. And here's me showing my age here, but under the good old Section 52, you had the pesky term a corporation. And you had to, if it was a person, you had to find all of these kind of technical arguments as to why the person should be dealt with under the Trade Practices Act. But now we have certainly a much easier go of things under Section 18 of the Australian Consumer Law. Let me just flip over to that wording for you because it's, where are we? So here, person must not in trade or commerce engage in conduct that's misleading or deceptive or likely. Okay, so we got a big tick there. Okay, in trade or commerce. Oh, hello to somebody. Under concrete constructions, we need to have activities or transactions which of their nature bear a what kind of character? Anyone got that one? Not very difficult. Okay. Now, really, this kind of factual scenario doesn't bear much discussion on the concrete constructions point, because it's not really, you know, you've got those finely tuned cases that the text goes into where, you know, you've got one person in a trade union providing advice to another person, you know, and you've got that obviously then throws up the very real question, well, was that kind of advice provided in trade or commerce? And there can be a very real debate about that. I mean, in the case I'm referring to, it was held not to be. But here you have, what's Roy doing? Is it in trade or commerce? I see some heads nodding. Yes, yeah. That, oh, hang on, it's not Roy at all, is it? Giving you a wrong steer there. Yeah, it's, yes, trade or commerce. He is trading as a fast food operator. Yep. No real debate there. Okay, misleading or deceptive. Okay. Good old Parkdale custom-built furniture. We need to consider the ordinary, reasonable consumer. So if the if the kind of people that would be misled would, you know, be the extreme minority, then you're not going to be getting over the line here. You're looking at the ordinary, reasonable customer. Who is our ordinary, reasonable customer? If you needed to define the class of customer here that we are looking at as to whether or not they would be misled or deceived, who is the class of customer? Can you tell me?
A hungry one?
Yes, absolutely. Class, sorry, that just tickled my funny bone. The class of customer is a hungry person desirous of a fast food meal. Now, here I'm trying to make that the purchase is not expensive. So you're not looking at the thing that they went on and on about in the Parkdale case was, well, hang on a minute, the class of customer here is the kind of person that's looking at buying, you know, a multi-$1,000 lounge suite. And, you know, if you're looking at a purchase like that, even the kind of people that would buy things fairly readily are going to try and make sure that they are getting the brand that they want. Okay. So you can be deceived easily if you're hungry. Sorry, I just saw that. I was really tough. So it's not expensive here. We're looking, oh, whoa, I don't know why I'm, there we go, at buying a, you know, $4 or $5 to less than $10 burger. The purchase is necessarily quick. That's the whole point of fast food. So probably not going to make a whole lot of inquiries about whether they're getting the brand, I'll put that in quotes because that really doesn't mean much legally, or the proper trademarked goods that they set out to buy. Yes? So that all adds up to the fact that they may be misled or deceived more easily. Yes? than perhaps someone that's buying a $2,000 lounge suite. Yeah. Is the conduct likely to lead into error? There has to be a real and not remote chance of being led into error. And this is decided as a question of fact. Okay. Here, what I want to draw your attention to is the fact that you are looking at, and the court's forensic examination is centred upon, the defendant's conduct. Okay? The defendant's conduct. So you are looking at what they did, what Fred did, and whether that was likely to lead into error. Okay? It's decided as a question of fact. Now, in the videos, I said, you know, the applicant doesn't really have to worry too much about proving reputation. It's certainly not like the action for passing off, where it is very squarely upon the applicant's shoulders to show on the civil burden of proof that they have a sufficient reputation. Here we are looking very squarely at what the defendant did. The only thing that the applicant will really need to show in the course of making argument that the defendant's conduct would mislead is that they'll need to show, you know, enough recognition of their brand to cause some kind of deception when Fred's brand was seen by the public. Okay? So you really only, your reputation comes into play really more when you're making arguments about whether or not the consumers are going to be misled because of what the defendant has done. Can you see the kind of fine line there? So what level of public recognition did we have of Nigel and Roy's mark, do you think? Can we hazard some guesses? I'll flip back up to, and again, we're kind of harking back to the kind of greyish arguments that we were trying to make in terms of reputation for the passing off action. Yes, because we really don't have a whole lot of information about exactly what level of reputation that they had out in the marketplace. We just really know that they certainly seem to be enjoying some good trade, which I guess, you know, means they have a certain amount of public recognition. But I've just kind of copied and pasted there because we can't make too many bold statements about their reputation given the lack of factual support there. Okay. However, even if we couldn't show a huge level of public recognition, we do have something that seems to help us, I think, in this case, in a Section 18 action. And this is an intention to deceive. Now, what do the facts show? And can we mount some kind of argument that Fred actually intended to deceive those customers, sold the burgers cheaper, and diverted the business to himself? Let's go back to our facts. Across the street. Hungry, eat at Max. Can someone throw me an argument? What would you be saying about those two things? Let me just get back down here.
I'd say he was trying to steal their thunder.
Yeah. Thunder. Yeah, I agree. I would argue that the fact that he set up his business directly across the street, and 2, he chose a name out of any name at all that you could think of, basically, because, I mean, he could call it his burger joint anything. That was, what is it? Hungry Eat at Max. Exactly the same as Nigel and Roy's. Let me do that, Roy's. Except for 2 words. And query how large or small those 2 words were in the exterior signage. I think out of those 2, if you have a little look at the Sydney-wide distributors case, and you have a little look at that snippet there that I put, where a trader having knowledge of a market borrows aspects of a competitor's get-up. Have you all heard the word get-up before? Sometimes it's used interchangeably with the words trade dress, okay? And get-up includes all the kinds of trademarks that do not include words, okay? Or they include words but in a specially stylized setting, okay? So usually when you're talking about get up, you'll be referring to things like the predominant colours used, or the format of the writing, or the shape of their packaging. Yes? So the Coca-Cola.
So you're talking about something like the McDonald's M's, the golden arches.
Yep, normally get up is kind of even broader than that. You know, get up can include, you know, it's almost like, you know how, I'm just thinking of a computer term, but the look and feel of something. So you walk into a McDonald's and it's almost, you can't quite put your finger on it, but the look and feel of each restaurant is very similar. And you might not necessarily put that down to one thing. It might be a number of different things. You know, the fonts that they use on their menus, the layouts that they have for their menus, the layouts they have for their counters, the kinds of posters, common posters that they usually have around the menu area, the seating area. All of those things can add up to be your trade dress or your get-up. Okay, it's like I said, sometimes you can't even really put your finger on it. Like if I said to you, you know, if you walked into a Hungry Jack's, what would immediately scream out to you that it was a Hungry Jack's restaurant? I mean, I guess you couldn't quite put your finger on one thing. Well, I guess you could. You would see a Whopper on the menu and you would know it was Hungry Jack's. But apart from that very specific trademark, there are a number of other things that would tell you immediately when you walked in the door, before you even saw the Whopper on the menu, that it was a Hungry Jack's restaurant rather than a McDonald's restaurant. Yeah. And this kind of look and feel stuff is very protectable. And this kind of look and feel stuff is called get up or trade dress. Okay, so where your competitor borrows aspects of your trade dress, it's a reasonable inference that he or she believes there will be a market benefit in so doing. Often the obvious benefit will be the attraction of custom, which would otherwise have gone to the competitor, that is the original proprietor. So I think, given that Fred has certainly borrowed aspects of our guy's get-up, you would say under the Sydney-wide distributors case, there would be a reasonable inference drawn that Fred intended to mislead or deceive. Yep. There is one other thing that they do discuss in the text, and I'll just mention it for you. I mean, I think, you know, under Section 18, Fred would more than likely go down. But they do mention in the text that you don't have to show that any particular customer was actually misled or deceived. I mean, that's obvious from the wording of the legislation itself, because purely the fact that we have something that's likely to mislead or deceive means that it hasn't happened yet, right? So you don't have to show that any particular customer was misled or I like Bianca's comment. Sorry, I just picked up your comment, Bianca. I'm not laughing for no reason at all. So you don't have to show that anybody was misled. But from, you know, jumping in on the bandwagon on a few of these cases, if you can show that you have a customer that's willing to testify that they were actually misled or deceived, it's gold. It's absolute gold. And if you can conduct some phone polls and show that people have been going to Fred's business on the basis that they thought it was Nigel and Roy's business, awesome. Awesome stuff. If you can actually show that there was verifiable deception going on. So even without that, though, I think Fred would be in a fair bit of trouble. Even if we couldn't get him on passing off, I think under Section 18. Is everyone kind of with me on that? Can I get a yeah? All right. So I think he'd be in some fairly troubled waters. Looking at question number 2, could Nigel and Roy object to McDonald's or Hungry Jack's opposing their trademark application as a misuse of market power? Could you say what you are effectively doing is merely using your market power to prevent me from getting my trademark? And unfortunately, I think there would be almost no chance of that happening. We know that we have to prove that the naughty person was a corporation. Well, you know, okay. Both McDonald's and Hungry Jack's have a lot of haters purely because they are large multinational corporations. So you got a tick there. Do they have a substantial degree of power in the market? Yeah, I see some nodding going on. Vanessa is nodding. Yes. Yep, we would definitely have a substantial degree of power in a market. It's almost a duopoly, isn't it, really? You got Macca's and you got Hungry Jack's and not a lot else, really. Here we have the sticky problem. Is them acting to oppose my trademark application a taking advantage of their power in the marketplace? Are they doing something that they couldn't otherwise do if they did not have that substantial degree of power in a marketplace. And this is where you have a lot of Section 46 actions falling down, okay? A lot of them do actually fall down on this second hurdle here, substantial degree of power in a market. And if you have a little look at the universal case that I set for reading this week, you'll see that this section is usually tossed in even when you would otherwise think that the corporations really didn't have any substantial degree of power in the marketplace. I mean, the ACCC threw in a Section 46 claim against Universal and Warner Music. And as I said on the video, I think Universal had about 17% market share, and Warner had 16% market share. And both, I think it was on trial and in the full federal court, they got up on Section 46, even with what you and I would think of as a relatively small market share. Nevertheless, first instance, full federal court, they got a tick under that requirement in paragraph B there. The High Court said no for a long-winded number of reasons. However, that doesn't mean that you could not get up on a Section 46 action with a relatively small amount of market share. I'm thinking of a couple of other cases where they've got up and there's only been around about 20 odd, or it might have been 21% market share. So don't think that substantial degree of power in a market actually requires more than 50% or somewhere close to 50%, because it doesn't, okay? It can be quite a lot less than that. Here, being McDonald's or Hungry Jack's, really, there's no issue, but the taking advantage limb is the one that I say on the video they wanted to get rid of in the competition policy review. And I think, it would have made eminent sense. And they also wanted to get rid of these rather cack-handed requirements. Really, that is a very bright purple, isn't it? I might just tone that down, shall I? Let's just, I'm having a psychedelic reaction. There we go. For the purpose of eliminating or substantially damaging a competitor, preventing the entry of a person onto the market, deterring or preventing competitive conduct. Okay, they're your three naughty purposes. So you're going to be taking advantage of your power for one of these three naughty purposes. And like I said, it's a bit cack-handed. It's a bit kind of unnecessarily complicated, and the competition policy review people did actually want to get rid of that. Unfortunately, the government said, we're too scared to do anything about this right now, and we'll do some more consulting, which normally means we'll just pop that in a bottom drawer and forget about it for another 10 years. So we're not going to be moving on this section in terms of reform, but I just wanted to quickly show you how difficult it can be to get across the line on a Section 46 action. And I think this is one of the more problematic High Court cases I've seen on a provision in the restricted trade practices provisions of the Bianca has mosquito problems. This is, has anyone had a look at this case before? No? All right, let me explain my rather cryptic looking diagram. It'll all become very clear in just a moment. So what we had was some competing newspapers, rural newspapers, okay, in the orange growing district of South Australia. So we had a newspaper in Murray Bridge and Mannum, and we had a newspaper in Waikerie. All right. Rural Press was actually quite a substantial corporation. One of its subsidiaries was Bridge, and they put out the Murray Valley Standard, okay? Now, Rural Press had been operating in Mannum and Murray Bridge for quite some time, and they were basically a monopoly in those two locations, Mannum and Murray Bridge. Mannum and Murray Bridge. They were basically the only thing that you could turn to, the only paper you could buy if you wanted loads of local content and you didn't want to buy, you know, the Adelaide Advertiser. In Waikerie, just up the river, we had another little printing press that put out a paper called the River News, and they circulated their newspaper in Waikerie only. And then Waikerie Printing kind of had some, I was going to say delusions of grandeur. They had some expansion aspirations, and they wanted to expand and circulate into Mannum and Murray Bridge. Rural Press is not small, and they don't take this kindly at all. And if you have, I didn't know if I'd have enough time, but I'm going to take you to do we have? No, we don't. I put a link in there to the summary of the case, but I'm going to take you to the case because it's rather, I was not prepared to see anybody in what you would think of as a relatively, pleasant country town, using some rather hard-nosed language that you would expect from a newspaper in Sydney. Let me just search on the word nice. There we go. Look, here. So one little worker at Rural Press, have a look at this, badgered her superiors for action and taunted them about their pusillanimity, urging them to show we're serious and asking if we are serious about our threat, saying we're looking like wimps. Oh, boy. That's kind of not the language you would expect in rural South Australia. But nevertheless, it looks like it's a newspaper war there as much like anywhere else. And so what Rural Press decided, I'll flip back here. Nice. Here we go. There we go. Free regional newspaper throughout the Riverland area. Okay, so they wanted to go into Mannum and Murray Bridge. They didn't want to play nice. We got Rural Press here going, oh my goodness, we're a monopoly now and you're going to start competing with us for customers, for advertising. We're not going to stand for this. And so Rural Press set up a meeting with Waikerie, and they said, if you don't stop circulating in Mannum and Murray Bridge, we, in all our monopoly might, are going to move into Waikerie, and we will decimate your circulation in Waikerie. Okay, we will not only move in, we will wipe you out. So what we want you to do is to agree to withdraw from Mannum and Murray Bridge. Yeah? Typical kind of threat that gets made by the big boys. Not surprisingly, before, I mean, it wasn't as though an agreement was reached, and that was part of the argument in the case, whether they'd actually made an agreement. But Wakery then graciously decided to withdraw from Manham and Murray Bridge. So Rural Press never ended up starting to circulate in Wakery. Okay. Would you think that this would fall into a classic kind of Section 46 scenario? On the face of it, you know, you've got this monopolist here. They certainly wouldn't be able to threaten to just start a whole new newspaper and flood the market in Waikerie if they didn't have market power, right? You would kind of think so. But the court said, no, actually, we don't think so. In terms of the market, they just looked at the market in Waikerie and they said, really, you know, despite the fact that Rural Press was a monopolist in Manham and Murray Bridge, they were a complete newbie in Waikerie. They had no market share in Waikerie. And really what they did by threatening to move into Waikerie was just use their financial resources and use their, what did they say? They used their material and organisational assets rather than their market power to threaten to move into Waikerie.
So is this similar to the Target and Target case that you were referring to earlier then?
Well, in the Target and Target's case, it was the little guy that was complaining, and here we also had Waikerie Printing complaining. Yes, absolutely. In Target and Targets, we certainly had a large conglomerate moving into the space of the small conglomerate. Yes. What we didn't have in Target and Targets was this very coercive behaviour. We're tired of playing nice, la-da-da-da-da. Wakerie's saying, we're going to move in to your patch. Rural Press saying, hang on a minute, you're the small fry, we're the big guys. If you move anywhere near us, we're not only going to move into your circulation area, but we're going to decimate you. We didn't have that extra layer of kind of overt nastiness going on. It really was all about business in Target and Targets. You had the big guy coming in and ultimately, you know, I don't know if the little teeny tiny Targets is still going in Hobart. Maybe someone can find out, Google it. But really there was just a case of, you know, big business just expanding its operations as it did. I mean, Target Australia was never going to be anything other than Australia-wide, you know. So I don't think there was any extreme prejudice shown to the little guy there. It just was unfortunate that they happened to have the same name. Here we had an actual communication from one trader to the other saying, you think you're going to take us on? Yeah, no way. Either you agree to move out of our market or we're going to decimate you. And that is the thing that tips it over into a very real risk that the ACCC will step in, as they did in this case, and say, hang on a minute, this smells like misuse of market power. And I really think that there was a lot of fancy footwork that the majority in the High Court did with this decision, and I'm not necessarily convinced, as are a lot of other commentators, if you have a look at the commentary on this, that it was necessarily the right reading of Section 46. But this is what we got on the books. This is what we currently have to work with. And it's just made all the more difficult by having these funny little take advantage of step. And, you know, the 3 naughty purposes steps. You know, it's, like I said, it's cack-handed, and I hope that someone in the government at some stage decides to take up the competition policy review's recommendations and run with them, because I think what they suggested was take this whole limb out, okay? So if you've got substantial degree of power in a market, you mustn't engage in conduct that would substantially lessen competition. The test from Section 45. The test that's also used in Section 47, and, you know, it runs through that whole division. And I think that would substantially free up the provision to be more liberally used. But like I said, we're stuck with it now, so this is what we got to work with. So I've just given you a little snippet from the case there. I'll pop these notes up online as I have, you know, in other weeks. How would Nigel and Roy deal with the opposition by McDonald's and Hungry Jack's if they couldn't get over Section 46? What would you do? You got 2 choices, really, haven't you? You either fight and you engage in opposition proceedings before the registrar, and that's what I did, because I'm a fighting tiny gal. What's someone saying to me here? Fight or flight. Yeah, I know. Exactly. That's your choice. Fight or flight. Give in. And you withdraw your trademark application. And this is what a lot of people do. If they're not actually too wedded to their trademark and someone like McDonald's comes up and opposes their application, they'll just, okay, that's fine. Here's evidence. We've withdrawn. Please go away now. We don't wish to engage in protracted legal proceedings with you. Yes. Often it's just the threat letter that'll do the job for someone like McDonald's or Hungry Jack's. You know, one simple cease and desist letter and they get their way. When I did my case for my opposition against Macca's, you know, we kind of collected together all of the trademark applications that McDonald's had opposed, which was a massive number, massive. And it was very interesting to see that a very good proportion of those applicants just chose to give in. If they hadn't even commenced trading under the mark, why would you go through the hassle of an opposition? You know, unless you got some reason to fight for it, most people would probably take option B. And that's why Macca's is Macca's. Yeah. As we saw the other day, who was it? I think it was Jacob that posted the tweet. You know, Macca's opposed McCurry. Or was that Bianca? Someone posed that in the forums. You know, Macca's has opposed McCurry. I mean, as if you'd be sitting in an Indian restaurant eating curry and thinking, I wonder if this is a new McDonald's franchise. I mean, it's quite scary what they will oppose, but there you go. That's why they have such a strong family of marks, I guess. So there's your 2 options there. The only other thing I wanted to leave with you was just, and I realise it's 7, so I won't labour the point, but I just wanted to make sure you knew what Section 47 did. Section 47. Corporations shall not in trade or commerce engage in exclusive dealing. Can anyone remember from your commercial law, corporations law unit what exclusive dealing is? The most common exclusive dealing is this one. So that can be 47.2. Has anyone heard the phrase full line forcing? Nope. That's a big nope. Full line forcing is where typically you are selling somebody goods or services that they really, really want. And you're kind of looking at their enthusiasm as a way of trapping them into just buying from you, okay? Maybe not just the thing that they want to buy from you, but also other lines of products that you sell that they may need to acquire and might otherwise acquire from a competitor, okay? So 47.2 is where you say, okay, I'll supply you my goods if you agree not to buy from other people, other competitors, okay? Naughty, naughty. If, and can I just say, all of these, 3, 4, 5, 6, 7, 8, 9, only are prohibited if they fall within paragraph 10. I don't even really know why the legislators decided to hide paragraph 10 down in paragraph 10. Because to me, logically, it probably should have gone up, in paragraph 1, maybe. But anyway, you're only going to be prohibited if your exclusive dealing substantially lessens competition. Okay? So you've got to look at 47.1 and all the subparagraphs read in light of section 47.10. Okay, there's going to be a substantial lessening of competition. But you'll see section 47.3, 4, 5, there's a whole batch of these provisions. So 47.2, as I said, is the classic case. If you supply on condition that the person that you're supplying to won't buy from competitors. 47.3, another case of exclusive dealing. And this is where you're forcing someone into a situation of what we call third line forcing. This is the third line forcing provision. Okay, you're agreeing to supply. Sorry, someone's just saying, no. Oh, okay, bye, Bianca. Have a good night. See ya. Okay, engages in exclusive dealing. If you offer to supply for the reason that they have acquired or agreed not to acquire goods or services from a competitor, and usually it's has acquired there. So you're supplying someone because they're getting their stuff from one of your friends. Yep, that's another naughty instance of of exclusive dealing. And you'll see paragraphs 4, 5, 6, 7, 8 and 9 are just variations on that theme. Okay, I won't worry about filling all of these in. You can go and have a little look at these in the legislation. But as I said, they're all really just variations on paragraph 47.2. 47.2 is the one that kind of tends to pop up most often. Okay, don't worry really too much about 11, 12, 13. They're just fairly arcane provisions. But just make sure that you know how 47 operates, because that's another really frequent problem with the restrictive trade practices provisions. Okay, any queries, questions? All make a relative amount of sense? Yes? Good. Joselito's nodding. Okay, Nadine's nodding. All right. Well, guys, we are 5 minutes past the hour. So thank your lovely selves for attending. And I'll put these up after the Zoom, and I'll pop the recording up as well. So apart from that, hopefully I'll get to chat with you in the forums, and I'll see you next week, guys. Thank you. Thanks. Bye.